Welcome to our webinar, How to Protect and Grow Your Social Welfare Business, presented by Wilby Limited in association with Markel. We have three great speakers lined up for you today, and we hope you find the webinar to be insightful and useful to your business. Some of you may already know me, but to those who don't, my name is Kath Johnston and I'm the Account Director for Care for Wilby Limited. We are a specialist broker for the social welfare industry and handle the insurance for more than 100 businesses in this sector. We work closely with Markel to ensure that our clients not only get the right cover, but also that you get specialist support services so that you can get on with running your businesses. So before we start, if you have any questions, please use the question panel and these will then be answered at the end of the session. Thank you. Without further ado, I'd like to welcome our first speaker, Kevin Hall from Gabelle, who is going to talk to you about that related to the care sector. And so over to you, Kevin.
Thank you, Kath. Yes, I work for a firm called Gabelle. Gabelle is a tax specialist firm. We advise on taxes across the board. I personally am a VAT specialist, so I'm going to talk to you today about VAT and how they relate to care homes. Just so that we all understand where we are, I wanted to run through very quickly the basic principles of VAT in order that we can try and minimise the VAT costs that arise in the care home sector. Everybody pays VAT on some or all of their costs, and if it's not managed, if it's not addressed, VAT can seriously impact on the profit of a business. And the principle of recovering the VAT that is incurred on costs is that you have to be able to attribute the costs to a taxable supply. And if you can't do that, then you can't recover the VAT, and the VAT becomes a cost to you as a care home. So let's look at what care homes actually supply. What care homes generally supply are welfare services. Welfare services are generally exempt supplies. Now what that means is that the VAT on your costs aren't recoverable. So how can we deal with that particular issue? Well, the best way of dealing with it is to make sure there isn't any VAT on the costs. You're going to look for zero rating from your suppliers. If you can't recover VAT and you can't get zero rating on your costs, you can look to try and ensure that the rate of VAT that you're being charged is not at the full standard rate of 20%, it's at a reduced rate of 5%. But sometimes you can't do that either, so you'd be looking to avoid the supplies that you make being exempt supplies, and that would give you the ability to recover the VAT that is charged to you. Let's look at zero rating as the first planning point. If somebody comes along to build a new block for you or a new place where your residents will sleep, could that be a zero rated construction, or are they going to charge you 20% for doing it? If you're able to satisfy the conditions for a relevant residential building, and I won't go into the technical details, you can then put pressure on your constructor to zero rate what they're doing. Now, it will only be the construction works that they undertake. It won't be the professional fees, unfortunately. So this isn't necessarily the only and ideal solution all by itself, but it's certainly something that you'd start by looking into. What sort of things that are constructed might be zero rated? Well, it's not just the blocks where people sleep. It can also be the amenities that they would use in order to use it as somewhere for them to live. So that would be the laundry block or somewhere to eat and so on. providing it's built at the same time as the area where they live, even if it's a separate building, you should be able to argue for zero rating with your supplier. If there is, however, an existing building, so it's not you're not building it from the ground up, you can't get zero rating on the construction of all of them, but you might be getting some alterations done to the building that you have in order to make it more suitable for people with disabilities, and that work can also be zero rated. So there's quite a lot of detail here to look at in order to try and secure the best VAT option when it comes to zero rating. Let's have a look at the next slide, which talks about the reduced rate of VAT. That's 5% instead of 20%. And you can secure that with your contractors if the building that was originally there was not the relevant residential building that you want it to be. So was it a care home before? Is it a care home now? You're creating a new care home, you'll be charged 5% instead of 20%. Just another little planning point, again, it's another little detail. Those professional services that you're buying, the legal costs, the accountant's costs, they've got VAT on, they're not being zero rated or at 5%. You can't get the VAT back when you're, let's say, buying bricks and mortar. It's being charged to you at 20%. What if you were to ask the contractor to buy the bricks and the mortar, to look at designing whatever it is that's being constructed for you? Well, those costs will then be charged to you at the rate that the contractor charges for the entire project. So it might be 0, that might be 5%, and you've got another saving there. But finally, let's look at the exemption on the supplies that are made by care homes. Now, it might be that you build a new care home and you supply it on. That would be a zero-rated supply, and there are ways to structure that. And that will enable you to recover all the VAT on the professional costs. But if you can't do that, or that isn't suitable for whatever reason, you can look at alternatives. Is there a way to avoid the exemption on the supplies that you're making? Well, the tests are that you need to be a qualifying body supplying qualifying services. Maybe you're not state regulated. Maybe you're not a charity or a public body. Maybe you're none of these things, and therefore you have to charge VAT on your supplies for welfare, but that enables you to recover the VAT on your costs. Similarly with the services, maybe what you're delivering isn't sufficient to qualify for the welfare exemption. Now that all sounds great. Recover the VAT on your costs. What could go wrong with that? Well, the problem is that you're now charging VAT onto your customers. If your customer's an individual, they can't recover the VAT, and you've generated a VAT cost in the entire structure, and that's what you want to avoid. So you'll be looking at whether your customers are possibly a public body or some sort of authority that can recover the VAT themselves, in which case you've eliminated the VAT cost throughout the supply chain. So moving on now to a final case study. This was a client that we had recently. They operated a care home. They owned several buildings that constituted the care home, and they were looking to obtain finance from the bank. And the bank quite rightly said, well, we're not going to give you so many millions of pounds in finance without some sort of guarantee that should things go wrong, we can recover our money. So they wanted to put a charge on the assets, which is fairly straightforward, but they insisted that each of the assets was held in a different limited company. You can understand that from the bank's perspective. They wanted to make sure that if something arose in one building, there was a negligence claim or what have you, and the liability was not transferred across to the other assets, and there was a ring fence in place. The trouble with that was that the buildings that were held in the existing company had to be transferred into other limited companies, and that was giving rise to a VAT charge which couldn't be recovered because the supply of welfare services was exempt. was just creating a cost out of nothing. There was £1 million of VAT at stake. As it happened, they were also trying to restructure, which is why they needed the financing. They were asking an operator to come in and provide the services that they wanted to step away from. And that operator was going to be charging VAT to them. Again, another VAT cost that they could not recover. I won't go into the detail of how we did it, but we looked long and hard at the entire situation, and we were able to find a solution which avoided the transfer, so there was no VAT charge there, and restructured the entire scenario to the bank's satisfaction and also to the satisfaction of the operator, so that everybody got out of the situation the monies that they thought they were entitled to, and there was no VAT cost. Always important to look at the tax scenario when it comes to care homes in order to get the best profits that you can from the scenario. And that's me. Thank you very much.
Okay, it's Jerry from Janjer, and I'm also part of Markel. And I hope you can see the slide in front of you. It's quite key because I want to talk to you about the changing litigious environment that we live within, what that means to you as a business. And I want to look at some quick wins in terms of how you might face some of the liabilities that are proposed your way from time to time, and how those might be managed down. I said that we live in a litigious environment, a societal context that has changed significantly over the years. And it seems to me that wherever you go, whether it's on the tube in London, whether you open your papers, whether or not you're watching the television, then you will see similar advertisements such as this, which can encourage people with vexatious, overstated, or sometimes fraudulent behaviour to propose difficulties to you in your workplace. Employer's liability is a key example of that. I've just got a few snapshots here which I think helps to understand what many care home providers face. The Association of British Insurers reported in 2014 that liability was a significant problem for them in terms of increased liability claims and associated arrangements. We also saw them reporting significantly increased fraud within the sector, and you can see that the type of levels that we're talking about and the increases, which are year on year, are troublesome. And I'm sure that there aren't too many of you who are free from some employees raising issues to do with the potential for a claim with you. And then lastly, in terms of the problem worsening, if you just look at the NHS Litigation Authority, you can see that for 1 year, the sort of costs that move through their particular books is considerable in terms of defence costs, the claimant's defence costs, and the grand totals. And that, as I say, is a snapshot of some of the legal expenses for 1 year for the NHS Litigation Authority. I did some research in Edinburgh at Napier University, and I involved some interesting bodies, so the HSE, IOSH, CIPD, ROSPA, and an international underwriter who was able to provide me with some anonymous data. And I also used a reference point in terms of 20 seriously experienced practitioners in the field to look at some issues related to this particular area of inquiry. One of the things that the background reading initially drew to our attention, and my attention in particular, was that there was an awful play, significant play on the role of health and safety in the workplace, and that's very important. But the research showed that, yes, it's important to have good health and safety management systems, risk assessments, and similar. But if you start to scrutinize the kind of sufficiency of those systems that are in place, looking at 1,000 providers of care, it started to suggest there might be some other matters of inquiry, other areas that would be useful to consider. So yes, pretty well all providers obviously had health and safety policies in place. They had incident and accident recording, but actually its sufficiency, certainly in terms of recording incident and accidents, tended to suggest that there might be some problems. When you then looked a little further into this area, taking 100 further service providers, we started to see some significant anomalies surfacing. And I think these particular areas are useful for you to consider in terms of your business, how it runs and how it manages some of the accident and incident arrangements. So we found good compliance in terms of dating, signing, and being generally dealt with in that administrative sense. But where things started to really become interesting was that we found that in significant incidents and accidents, managers scrutinizing, signing off, having a view on the nature of those incidents and accidents was far less, as you can see from the graph, than perhaps we might have expected. And lastly, there was very, very little discussion on the culpability of staff in any of the accidents and incidents that were scrutinized. So if you look at the bottom block, do managers sign off accident and incidents? I'd like to hope that that was probably a yes from all of you that are in today's discussion. But if you carry on up the tree of blocks, do managers analyse the event and consider liability factors such as language in terms of how claims may be relatively overstated at an early stage, and then at a later stage, when a litigious no-win, no-fee solicitor gets hold of it, the use of language creates additional fees or anticipated payouts in that sense. In other words, the quantum of the claim is not controlled at an early stage. Do managers look at corrective actions, risk controls, defending further on issues to do with, well, this accident happened, you knew about it, did you do anything to reduce the likelihood of its occurrence? Moving on up the tree, do the significant incident accidents formulate around whether or not there is any staff culpability? And that's really, really important. So can some of these changes, certainly around discussing whether or not there is any staff culpability, make any difference? Managers intervening and reducing the language that's used in some of the accident and incident forms, which can be quite florid in terms of their detail, when seen in the cold light of day many months later. But you'll see from this slide that there are a number of providers who were approached. They had significant claims history, and following some discussion on the very specific areas that we're covering here, the claims experience dropped very significantly. And the last point on that slide, a fourth provider who has had repeated training in liability dampening and claims defence, reported an 80% fall in what they consider to be fraudulent and certainly exaggerated claims over the 2-year period, 2015 to 17. So, last slide, watch points to consider, I would suggest. So, do your systems indicate that staff generally fill in their own accident and reporting systems? Because if they do, and you don't control that particular aspect of the process, managers are not involved, then there will be difficulties in terms of generating a reasonable position around liability defence. Is a manager or a supervisor required to sign off those documents? And controlling the narration. It's really important, I've seen this in so many accident and incident forms, where the language that is used means that the quantum of the potential claim and the eventual settlement is out of step from the original injury. So has an investigation for any potential liability been actioned? Is it focusing on duty of care? Have risk controls been assessed and risk controls introduced to avoid a repetition? But more so, has the account of the manager sought to ensure that any liability and negligence of the employer is discussed? So moving towards the end, has negligence been factored in the discussions, and does this link with any disciplinary investigations? So what I'm saying to you, I think, in summary, is that a no-win, no-fee solicitor will be very unlikely to take on a case and push it through where it's clear their client has been negligent in the matters around any particular incident and accident. We're in a care profession, and most people do generally not consider the issues formally of the role of the staff in some of the incidents and accidents that occur to them. So think about it, maybe approach things in a slightly different way, and I think you'll find it'll make a difference. Thank you.
So good afternoon, everyone. Just following on from Jerry's really interesting discussion there. I'm Gabrielle Potter, and I'm a team of 8 people in the claims team at Markel, which is headed by claims manager Helen Fagg. Our claims team is split into 2 sub-teams, one that deals with professional management risks claims, for example, claims against architects or accountants, and the other team dealing with social welfare claims. I'm partly here today to tell you a little bit about the social welfare claims team, of which I am part of. In the social welfare claims team, we deal with a variety of different insureds, including those working in the social welfare care sector, educational establishments, charities and community groups, and not-for-profit organisations. I'm a claims adjuster within the claims team, but in terms of my background, I qualified as a solicitor back in 2010, and in a former work life worked at a law firm dealing with employers' liability and public liability claims, amongst others, on behalf of insurer and adjuster clients. I joined Markel in 2015, and since then I've studied towards and completed the Diploma in Insurance. I've also recently been awarded the Chartered Insurance Institute's 2017 Catlin Award for Excellence in Claims Practice. I work alongside Pippa Hayden-Dainty, who you can see there just at the top of the slide. She heads up the social welfare team and is a senior claims adjuster. Pippa also qualified as a solicitor in 2010 with a family law background. She also has a good deal of experience hands-on working within the care sector. Pippa and I are joined by Megan Hodson, who's just at the bottom right of the slide there, who is a claims adjuster and has a legal background, having previously worked as a paralegal at a national law firm. Both Pippa and Megan have been awarded their diplomas in insurance recently and are both studying towards their ACII qualification. Megan, in fact, has just recently been inducted onto the Chartered Insurance Institute's 2017-18 New Generation programme, which will see her, along with peers, complete a project or an initiative that they believe can make a real difference to the insurance profession. Overall, and in a nutshell, the social welfare claims team at Markel have a good deal of experience when it comes to handling the claims that come through our door. We see and we deal with a real variety of claims. Memorable examples would include, say, the theft of £500,000 from a charity, and a simple EL trip over a wire which resulted in paralysis. The more frequent types of matters we see, however, would include employers' liability and public liability claims. The great majority of employers' liability claims that we receive arise out of service user assaults, followed by slips and trips and manual handling injuries. In terms of public liability claims, these would include the classic occupiers' liability type claims where injury has been sustained to a member of the public or a third party whilst on premises occupied by the insured. Alternatively, public liability claims would also include third party property damage claims. One recent example that I've come across is a farmer claiming for service users causing damage to his combine harvester. We also see professional indemnity claims, which would be a scenario arising out of a failing or possible failing in the insured's professional services. An example would be a complaint or a claim with regards to the level of care provided to a service user. So just briefly, other examples that we see across our desks would include directors and officers claims, employment law claims, fidelity claims, for example, misappropriation of the insured's or somebody within the sector's funds by an employee, and first-party property claims, which would include, say, claims for storm damage or escapes of water. Simply put, taking into consideration the experience and the expertise that we have in the social welfare claims team, we're of the view that this stands as an excellent step to deal with claims on behalf of our insureds effectively and efficiently. In terms of handling and dealing with claims, everything we do is in line with Markel's claims vision, which is to be the most customer-focused, nimble and value-adding claims team in the market. I wanted to speak really briefly today about claims trends that we're seeing at Markel, and given that employers' liability and public liability claims are the most frequent, I decided to focus on a couple of trends from this perspective. First relates to those employers' liability and public liability claims that are worth less than £25,000, and on that basis they should be submitted to us by the claimant solicitor via the online claims portal. For those that don't know, the claims portal was originally set up to swiftly and cost-effectively deal with EL/PL claims with a value of up to £25,000. Generally speaking, the majority of liability claims that Markel receive are employers' liability and public liability portal claims, and roughly we receive, say, 25 to 30 of these every month. Ideally, if the claim is one where liability is to be admitted and it's therefore one to settle, we want to keep the claim within the portal process as we get the benefit of fixed portal costs, and on that basis the claimant's costs will be capped and kept to an absolute minimum. On the other hand, however, being a cynical claims adjuster that I am, the claimant solicitors want the claim outside the portal process in order to maximise on their recoverable costs. One trend that we are seeing time and time again for us as insurers of businesses within the social welfare and or care arena is an exclusion contained within the portal rules, which specifies that the portal does not apply to a claim for damages in relation to harm, abuse or neglect of or by children or vulnerable adults. My own interpretation of this wording is that the portal is not suitable for a claim brought by children or vulnerable adults for harm, abuse or neglect. What we're seeing, however, are firms of claimant solicitors arguing that the portal process does not apply in literally every scenario which involves a child or a vulnerable adult, regardless of whether or not they are the claimant. We appreciate that claims by children or vulnerable adults which do arise out of harm, abuse or neglect are probably not suitable for handling within the portal due to complexity. That said, we're seeing claims whereby a child or a vulnerable adult has assaulted an employee or indeed a member of the public, and given that the incident involved a child or a vulnerable adult, the claimant solicitors argue that it's not suitable for the portal process. My view, and one that's shared with our panel lawyers, is that the exclusion in the portal protocol wording is somewhat poorly worded, and excluding claims such as assault on employees by children or vulnerable adults was simply not the intention of those drafting the wording. There's simply no reason why these claims cannot be handled within the portal. In terms of tackling this particular trend, one of our firms of panel lawyers are currently holding talks with the Association of British Insurers in relation to the issues that we're coming across. They are also seeking to amend the portal guidelines to tighten up this loophole and prevent claims dropping out of the portal process on this basis. In the circumstances, this is very much a watch this space. Leading on from this brings me on to the second trend, which we are coming across relatively often nowadays. There are some claimant solicitors who essentially manufacture claims, or want to manufacture claims out of nothing, or increase the value of the claim to take it over the low value portal threshold of £25,000. This is with a view to getting more by way of their recoverable costs. An injury that we're seeing alleged more frequently at the minute is subtle brain injury. This is obviously something that is seen in sports such as rugby or football, but we're seeing such injuries alleged particularly in employers' liability claims where an employee has been assaulted by a service user. We've even seen subtle brain injury alleged in a claim where the employee fell from a swing whilst at work and hit his head. With these types of claims, we found that at the time of the accident, there's little to suggest that any serious injury has been sustained, but over time, the development of headaches, irritability, reduced concentration, fatigue, along with hallucinations, amongst others, are alleged. I don't want to cause any harm flagging these types of claims, but it's definitely worthwhile making you aware that it's a trend that we're seeing from claimant solicitors. In terms of challenging and drilling down on these subtle brain injury type claims, we found internet profile reports to be of significant use with a view to ascertaining the claimant's functioning, whether they're able to work, whether they're socialising normally, and so forth. For those that don't know, internet profile reports are essentially reports that we can obtain which review the claimant or their known associates' Facebook, Twitter and Instagram pages to see what they're up to. With reference to the example provided before of the employee that fell from a swing, we did obtain a very useful internet profile report which demonstrated that since the alleged incident, he was able to travel abroad, sing and perform in a band, and he also had a very active social life. In a nutshell, there was absolutely nothing to suggest that he'd suffered from any physical or psychological injury. We denied liability on that particular claim, and the date for service of any proceedings has long since passed, so we considered that to be a real success. Moving on to claims reduction strategies and tactics, and just following on from what Jerry was saying a little bit earlier, from a claims perspective, if there are things we can do to 1, cut down the number of claims, 2, assist our insureds to be in a position where they and we can successfully defend claims, and 3, educate our insureds about claims and processes, then we will do so, and we're happy to do so. I thought it would be useful to highlight here some of the issues that we do come across when dealing with those employers' liability and public liability claims that we could have perhaps defended, but we then end up having to settle on the best possible terms. Examples which may be of interest to you would include a lack of available documentation. So for talking, say, any contemporaneous accident-related documentation or documentation demonstrated safe systems of work and training. The existence of documentation, the contents of which are completely at odds with the circumstances of the accident in question, is another example. One that would immediately spring to mind is, say, in respect of staffing ratios. So you could have a ratio where a service user has been provided 1-1 care and a document expressly stating that 2-1 pairs should be implemented. If an incident occurs when the correct staffing ratio is not being implemented, the existence of such a document is not going to help us in the event of a formal claim. In terms of the recording of incidents, we do come across issues in this respect. We have on occasion come across incidents involving employees where the injured employee has completed the accident book and there's been no checks or balances or any counter signature from a manager. This has caused a difficulty in the past where our insureds have disputed that any such accident occurred because documentation to the contrary in existence. Finally, issues securing witness evidence is another problem that we come across on occasion. In a social welfare or care type setting, there can often be a high turnover of staff or use of agency staff, which can result in us being unable to track down or locate witnesses at the point where we need to be collating witness evidence. Witness evidence about the circumstances surrounding the incident is often crucial to us defending the claim, and we do sometimes find ourselves in difficulty when we're unable to make contact with witnesses, or we come up against a witness who since moved on and is just simply reluctant to assist. We do defend claims where we consider that they are without any merit, but unfortunately there are some circumstances where we do have to proceed to settlement in the event that we consider the insured will be found liable, or if it will be risky or simply just not cost effective to run the claim to a full trial. In those scenarios, we at Markel do our best to get the best possible outcome for the insured, and this would include using various strategies and tactics, some of which would include, say, obtaining our own medical evidence to challenge the evidence that the claimant has obtained, and those would be in suitable cases of higher worth. As previously mentioned, we do obtain internet profiling reports in claims where we feel that there could be an element of fraud or exaggeration on the claimant's part. We do also, in some instances, proceed to obtain surveillance in order to challenge the claim. Just yesterday, actually, I had a rather claim with some potential discontinue, because we got some decent evidence to suggest that the accident didn't happen as alleged. This is a lady that said she'd slipped on spillage whilst at work, and the internet profile report demonstrated that she'd posted numerous posts on Facebook to the effect that she'd simply missed her footing and fell down a couple of steps. Our panel adjusters and solicitors also monitor claimant solicitors' behaviour and tactics, and they do come up with counter strategies to address the common issues that we experience. We come across solicitors that simply refuse to engage over the telephone, and they include an element of psychological injury to inflate the claim, and they do overvalue claims. We can challenge these behaviours with following up all failed telephone calls in writing, putting forward early and good offers backed with evidence to try and swiftly settle claims, and also by challenging or objecting to the use of experts proposed by claimants if we feel that the claim is inflated or overvalued. We also do try and take advantage of certain times of the year where claimants or their solicitors would welcome some cash. We would do this to make a significant, or attempt to make a significant saving on outlay. So times of year where we do see significant savings made on damages and costs can be, say, Christmas for claimants, because who doesn't want money at Christmas, and the accounting year end for claimants and solicitors. So we always find these interesting times of year. On occasion we've saved into 5-6 figure sums. So I do appreciate that this has been a bit of a whistle-stop tour as to who we are, some of the employers' liability and liability trends that we're seeing, and strategies and tactics that we can use, but I do hope that it's been of interest to you.
Thank you all for listening, and I'd like to thank our speakers, Kevin from Gabelle, Jerry from Janjer, and Gabrielle from Markel Claims. Thank you for your time, and if you do have any questions, please let us know, and hopefully we can answer them for you.